You're watching Good Day Orlando on Fox 35.
To be a mess.
Yeah, also a developing story. Reaction is still pouring in from all across the United States after the Supreme Court's Hobby Lobby decision.
That ruling allows some companies with religious objections to opt out on providing contraception to employees. The High Court ruled 5-4 to allow the exemption to the health care law. Hobby Lobby had argued that being forced to provide some birth control goes against their religious principles. Hobby Lobby's owners are pleased with the ruling, but some lawmakers are not.
We are truly thankful for a decision that allowed us to continue operating our family business according to our principles. We thank God for his many blessings and ask for his continued grace to shine on our nation.
Women ought to make decisions based on their beliefs, not the beliefs of their employers. It's that simple.
And joining us right now, Rachel Gebaide with the labor and employment practice at Lowndes Law Firm. She's here with today's Legally Speaking. Good to see you, Rachel. Thanks for coming in this morning.
Hi, Amy.
So do you think this decision is going to tilt other legal action in favor of corporate religious beliefs? Because this was a big decision yesterday.
So it could, Amy. Remember, this is a 5-4 decision, and it was very broad and sweeping according to Justice Ginsburg's dissent. What the decision is on its face is narrow. It pertains only to the contraceptive mandate under the Affordable Care Act, and it says that for-profit, closely held companies, so as of yesterday, we're not talking about publicly held companies, but for-profit, closely held companies with a sincere religious belief would be able to claim the exemption from the contraceptive mandate under the Affordable Care Act.
So how does this work now? Can a company now step forward and say, you know what, we agree with Hobby Lobby, we would like to do this too?
If they assert, if a closely held for-profit company asserts a sincere religious belief, and the courts do not like to meddle into whether an individual claiming religious liberty has a sincerely held belief, and now they're extending that liberty not just to individuals but to for-profit closely held corporations as well. If they say we have a sincerely held religious belief, and as a result of that we do not want to provide contraceptive coverage through the insurance that we now have to provide to our employees under the Affordable Care Act, they would be able to claim the exemption.
So what, the people who work for Hobby Lobby, what now happens? That say they still would like to get these contraceptions. Obviously they still can, but do they have to pay for them out of pocket completely now?
So, well, it wouldn't be covered under the insurance plans provided by their employer. They could either get coverage through a spouse's employer, but right now, after yesterday's decision, what we may see are additional regulations or Congress going back and taking a look at what they can do. But what we see are regulations that would perhaps provide for government-paid contraceptive coverage for those employees who are not able to obtain coverage through their employer's plans.
Well, it certainly is fascinating. It's a big talker today. A lot of people still talking about it. Rachel Gebaide with Lowndes Law Firm. Thank you so much for coming in this morning and sharing your expertise.
Thank you.
All right. Still to come this morning.